The Election Petition Tribunal is a waste of time.
Tomorrow is the final day that Nigerians have to stop the swearing in of Tinubu on May 29th, 2023. Either he is stopped by the Federal High Court in Abuja or the Supreme Court in Abuja. In the case at the Federal High Court that was supposed to be held yesterday, but the judge was nowhere to be found. The judge didn't communicate to the appellants and everyone that came to court that he wasn't going to come. Maybe he had an emergency. Anyway, people were later communicated that the court will now sit on Friday, the 26th day of May 2023. In the matter before the Federal High Court, Abuja, Nigerians resident in the FCT are asking the court to stop the inauguration and swearing in of Tinubu because he did not meet the constitutional requirements. They are also asking the court to make a pronouncement and determine if 25% is truly required in Abuja. The issue of the presidential candidate scoring 25% in Abuja has been a bone of contention for the past few months. Before the election, many, even those in the APC, always said and maintained that 25% is a must, that a presidential candidate must score 25% in Abuja, including 24 states in Nigeria.
The second condition is that you must win 25% votes across
states.
two-thirds of Nigeria's 36 states, which is 24 states, plus it is an and FCT.
You must win FCT.
You must win at least 25% in FCT.
Okay.
So even if you win those 24 states, you have 25%, but you don't get 25% in FCT, there's a problem.
But after the election, most of them are now changing their words, saying that A is not really needed, that Abuja is supposed to be taken as the 37th state in Nigeria. And it's clearly written in the constitution that Abuja is not a state. Rather, it's the territory of the president. The president cannot be functioning under a governor. That was why Abuja was created, just like in Washington, D.C. Washington, D.C. doesn't have a governor, it only has a mayor. So in the case of Nigeria, the president appoints a minister that will oversee affairs in the Federal Capital Territory.
In the Federal Capital Territory, we require 282 SPOs.
If the executive arm are not lawless, they are supposed to be the ones that should approach the court for interpretation in case they are confused. But they are not confused, they know what they are doing, because Buhari himself had a judgment against him based on the 25% in Abuja. Not once, but twice. So they are well aware that 25% is required and are bent on violating the Constitution of the Federal Republic of Nigeria. So this is the main reason Nigerian voters in Abuja went to the Federal High Court to seek interpretation. INEC also are supposed to go to the court when some people were talking about it before the election, that they should seek interpretation in the court to know what they are doing. But as usual, the way they are always lawless, they refuse to seek any advice from the court. They don't even supposed to bring any suit at the court. They can just, on a mere discussion, discuss with some of the jurists in the court if they truly want to do the right thing. But instead of doing that, they would rather spend more than 3 billion naira in court to defend an election that they know very well that they did not follow the laws. They rigged the election in conjunction with all the parties that they supported. These guys are just wasting Nigerian people's money for nothing. Why should they require additional 3 billion naira to go and defend a flawed election?
So we're here.
On the part of the judges, they are making it seem as if being a judge is the hardest work one can do in the world. Why do they make it very difficult to get judgment in Nigeria? Granted that all the petitioners did not demand that the 25% should be resolved before they even enter pre-hearing period. None of the parties demanded that, but the court should have said, okay, let's look at the most simple ones to determine. Being a judge is not hard. You have a formula. You have the law. If the law says this and that, says ABC, and you have someone in court that it is proved that he did CBD, it's quite different from what the law says. So you should bring the hammer. You look at the law again, what it says that should be the punishment. You just write your sentence. It is as simple as ABC. But here they are making it seem as if it's a very hard job. It's not a hard job. In the United States, remember that citizens are the ones who convict someone. They have a jury system. Before any trial starts, they do a jury selection where they select ordinary citizens that will sit down in court, hear all the cases, hear the trial. At the end of the trial, they are now presented with the information. Look at what the law says. Look at the penalties. Please make a decision. It is very simple. These are ordinary citizens who don't have any legal background. They are not lawyers. But because the law is written in English language and they know their left from the right, they know good and bad. Every human being has a conscience. You know what is good, you know what is bad. So when you see all the evidence and you know, look at what the law says, look at the punishment, just apply it. The work of the judge in the United States is just to write the sentence. It is the citizens that convict the person. So in Nigeria, they make it look as if it's a huge thing to do. Why are they running away from the court? Why are they running away from judgment? Why are they making it seem that they need 1 week? Talking about the tribunal right now, they need 1 week to decide on the 25% requirement in Abuja. Or is there something they know that Nigerians don't know? All of them are avoiding the issue of 25% before the swearing in. Why? The question is, why are they avoiding it? Are they trying to say that it is not the way we see it, that the law sees it, despite all the precedents, all the judicial precedents where they have ruled that 25% is a requirement, that it is a must, that for someone to be declared winner, the person must score 25% in Abuja? If they do it after the fact, after the swearing in, then that means they are in bed with the people that Nigerian people are fighting. Because you can't say, they say that silence is complicity. If they know that it is wrong and fold their hands and the wrong thing is done in our country, then they are complicit, no matter how they want to see it. All of them are adjourning the matter so that there won't be enough time to rule. Time is running out. Even if they deliver judgment tomorrow in the positive, there's no guarantee that the executive arm will obey the judgment. You know their records on court order, so it won't be surprising. Also, they might say they are appealing. Of course, everyone has the right of appeal, and they will use that and say, okay, pending the appeal, we will not stop execution, we'll go on with the inauguration anyway. So it serves no purpose. This is something they should have done long ago, ever before the pre-hearing. They should have said, okay, let's tackle all the ones that are easy, that doesn't require any witness or anything. It's just to interpret the law. The tribunal should have done that early before the pre-hearing. Anyway, be rest assured that we will bring you all the updates. Tomorrow is the D-Day. There are 2 judgments that can still stop the swearing in of Tinubu. Thanks for watching.
97, 98, 99, wonderful! Come on! Come on! Come on! Wait. You never finish. You never finish. You never finish. You never finish.